has published the regulations implementing the new E-3 visa for Australians. With the publication of the final rule, Australians are now able to apply for E-3 visas to work in the United States. What is the E-3 visa classification? The Emergency Supplemental Appropriations Act for Defense, the Global War on Terror, and Tsunami Relief Act of 2005, signed by the President on May 11, 2005, established a new non-immigrant visa category, the E-3 visa category for Australians. The Act provides for 10,500 new E-3 visas per fiscal year for Australian professionals seeking temporary work in specialty occupations as defined under the H-1B provisions of the Immigration and Nationality Act. Who qualifies for E-3? The new E-3 visa classification currently applies only to nationals of Australia as well as their spouses and children. E-3 principal non-immigrant aliens must be coming to the United States solely to perform services in a specialty occupation. What is a specialty occupation? In general, a specialty occupation is one that requires theoretical and practical application of a body of highly specialized knowledge in professional fields that requires at least the attainment of a bachelor's degree or its equivalent as a minimum for entry into that occupation in the United States. In order to determine what constitutes a specialty occupation, consular officers abroad will be guided by and will apply the regulatory criteria already developed by the U.S. Citizenship and Immigration Services for H-1B applications. What are the other requirements to qualify for an E-3 visa? An E-3 visa classification is numerically limited, with a maximum of 10,500 visas available annually. Spouses and children do not count against this numerical limitation, nor are they required to possess the nationality of the principal. Before an Australian national can file for an E-3 visa, a labor condition application, E-3 visa LCA, containing attestations by the sponsoring employer related to wages and working conditions, must be filed with and approved by the Department of Labor. At the time of the visa application, the visa applicant must present the consular officer with the original or copy of the approved E-3 visa LCA. However, if the applicant cannot provide the original, the consular officer, at his or her discretion, may accept a certified copy of the approval. The approved LCA represents DOL certification that the employer has met the attestation requirements of the E-3 statute. Does it require filing of a prior petition in the U.S. before the visa issuance? No. No petition to the USCIS is necessary. Instead, in the case of an employee seeking an E-3 visa, the employee will present the necessary evidence for classification directly to the consular officer at the time of a visa application. Such evidence will include the original or copy of the labor condition application, signed by the prospective employer and approved by the DOL, a letter from the employer describing the employer and the position in the U.S., and the applicant's qualifications for the position. Let's look at procedures for the E-3 visa for Australians. These are similar to those established for obtaining the H-1B1 classification under the U.S., Chile, and the U.S., Singapore free trade agreements. All right, let's look at a quick case. Paul is a graphic designer in Melbourne, Australia. He and his wife have wanted to live and work in the U.S. for a long time. Paul got a job offer from a company in Denver, Colorado, and is now preparing to get his visa. The company sent him the certified LCA, a job offer letter, information about the company, and a lengthy job description showing the need for a BS in graphic design to be able to do this job. Paul gathers his college diploma and transcripts, awards, and certificates for the work he has done, and heads out for his visa interview. He is well prepared and comes home with the E-3 visa, and his wife has her E-3 as a dependent. They finish packing their stuff, put the balance into storage at his parents' place, and head for America. What other supporting documentation is needed for the E-3 visa application? The following documents will be required to establish eligibility for E-3 visa issuance. The approved labor condition application, we've talked about this a couple of times, which the U.S. employer obtains from the Department of Labor, the job offer letter from the prospective United States-based employer, evidence of academic or other qualifying credentials. If your degree and higher level qualifications are from an Australian institution, you do not usually need to provide certified copies or evidence of their U.S. equivalency, but you must bring them to the interview, copies of the certificates and transcripts for the officer to look at. If your qualifications are not from an Australian institution, a certified copy of the foreign degree and evidence that it is equivalent to the required U.S. degree could be used to satisfy the qualifying credentials. In the absence of an academic or other qualifying credentials, evidence of education and experience that is the equivalent to the required U.S. degree. Next, a certified copy of any required license or other official permission to practice the occupation in the state of an intended employment if it is required. Where licensure is not necessary to commence immediately the intended specialty occupation employment upon admission, evidence that you will be obtaining the required license within a reasonable time after admission. How to file the E-3 visa LCA. Employers seeking to sponsor workers under the E-3 visa category must file the LCA Form ETA 9035E through the Department of Labor's website. The employer must follow the instructions for the electronic submission posted on that website. Note, an LCA may be filed by U.S. mail only if a physical disability or lack of access to the internet prevents an employer from using the electronic filing system. Employers wishing to file LCAs by U.S. mail may submit a written request to the Chief for the Division of the Foreign Labor Certification, establishing his need to file by mail, including providing an explanation of how the physical disability or lack of access to the internet provides him from using that electronic filing system. Employers may also be required to support submitting documentation to establish that physical disability or lack of access to the internet. If the request is approved, the employer may use the Form ETA 9035 and send it to the ETA by U.S. mail. When it's submitted by mail, the form must bear the original signature of the employer at the time it's submitted. How do you apply for a change of status to E-3 classification from within the U.S.? To apply for a change of status to obtain E-3 non-immigrant temporary worker classification, Form I-129, Petition for a Non-Immigrant Worker, must be filed with the USCIS along with all the supporting documentations. These include the labor condition application, the academic or other credentials demonstrating qualifications for the position, the job offer letter or other documentation from the employer establishing that the alien will be engaged in a specialty occupation and that he will be paid the higher of the actual or prevailing wage, and, if required, before the alien may commence employment in the specialty occupation, the necessary license or other official permission to practice in the specialty occupation. Let's look now at the spouse. Can the spouse of an E-3 non-immigrant work in the U.S.? Yes. INH Section 214E6 permits the spouse of a Principal E non-immigrant to engage in employment in the U.S. As is the case for the spouse of the Principal E1 and E2 non-immigrants, the spouse of a qualified E3 non-immigrant may, upon admission to the U.S., apply for an employment authorization document, which an employer can then use to verify the spouse's employment eligibility. Such spousal employment may be in a position other than a specialty occupation. If you have any further questions on the E3 visa or require assistance for filing for an E3 visa, contact VisaPro. Our experienced attorneys will be very happy to assist you.